Bharatiya Sakshya Adhiniyam 2023. Previously, it was described in Indian Evidence Act. Now, Indian Evidence Act will change and its new name will be Bharatiya Sakshya Adhiniyam 2023. It is not notified till now. Sections 20 of Indian Evidence Act. Now it will change Section 18 admission by persons expressly referred to by the party to suit. Previously it was described in the sections 20 of Indian Evidence Act. Now it is described in section 18 of Indian Evidence Bharatiya Sakshya Adhiniyam 2023. Section 18 according to Bharatiya Sakshya Adhiniyam 2023, 18 is given admission by persons expressly referred to by the party to the suit. The statement made by the persons to whom a party to the suit has expressly referred for the informations in reference to the matter in dispute are admissions. Section 19 of Bharatiya Sakshya Adhiniyam 2023. Previously it was described in section 21 of Indian Evidence Act. Now 21 of Indian Evidence Act, now it will change section 19 of Bharatiya Sakshya Adhiniyam 2023. Now I am going to describe about that. Proof of admissions against the persons making them and by or on their behalf. Admissions are relevant and may be proved as against the persons who makes them or his representative in interest, but there cannot be proved by or on the behalf of a person who makes them or by his representative in the interest, except the some cases, namely, number 1, an admissions may be proved by or on the behalf of a persons making it when it is of such a nature that if the persons making it were dead, it would be relevant as between third persons under the sections 26. Section 19 subclause 2, an admissions may be proved by or on the behalf of a person making it when it consists of a statement of that existence of any state of mind or body relevant or in issue made at or about the time when such a state of mind or body existed and accompanied by conduct rendering in falsehood improbable. Section 19 subclause 3, an admissions may be proved or on behalf of the persons making it is relevant otherwise than an admission. Sections 22 of Indian Evidence Act, now it will change in the Bharatiya Sakshya Adhiniyam 2023 in section 20. Means previous it was described in section 22 in Indian Evidence Act, that now changes in Bharatiya Sakshya Adhiniyam 2023, it is described in sections 22. When oral admissions as the content of the document are relevant, oral admissions as to be content of the document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the content of such a document under the rule hereinafter contained or unless the genuineness of a document produced is in question. 23 of Indian Evidence Act. Now it will change 21 of Bharatiya Sakshya Adhiniyam 2023. It is given in admission in civil cases when relevant. In civil cases, no admissions is relevant if it is made either proof or express conditions that evidence of it is not to be given or under circumstances from which the court can infer that the parties together that evidence of it should not be given. Sections 24 of Indian Evidence Act now changes in Bharatiya Sakshya Adhiniyam 2023 in sections 22. Confessions caused by the inducement, threat, coercions or promise when relevant in criminal proceeding. Means previously it was described in Indian Evidence Act, it is described in sections 24. Now it is described in sections 22 of Bharatiya Sakshya Adhiniyam 2023. In 22 Bharatiya Sakshya Adhiniyam 2023, sections 22, confession caused by inducement, threat, coercions or promise when irrelevant in criminal proceedings. A confession made by an accused person is irrelevant in a criminal proceeding if making of the confessions appeared to the court to have been caused by any inducement, threat, coercion or promise having reference to the charge against the accused person proceeding from the person's ground which would appear to him reasonable for supporting that by making it would gain any advantage or avoid any evil of temporary nature in reference to the proceeding against them, provided that it is confession is made after the impressions caused by any such a inducement, threat, coercions or promise has in the opinion of the court been fully removed, it is relevant. Provided further that if such a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in obtaining it when it was drunk of because it was made in answer to question which he need not have answered, whatever may have been the form of those questions, or because he was not warned that he was not bound to make such a confession and that evidence of it might be given against him. Now, Indian Evidence Act 25, 26, 27 that now came in the sections 23 in subclause 1 and subclause 2 means 25, 26, 27 confession to the police that now according to Bharatiya Sakshya Adhiniyam 2023 it came in sections 1 and 23 subclause 1 and subclause 2. No confessions to a police officer shall be proved as against the person accused of any offence. And subclause 2. No confession made by any person while he is in the custody of a police officer unless it is made in the immediate presence of magistrate shall be proved against him, provided that when any fact is disposed to as discovered in consequence of informations received from a person accused of any offence in the custody of a police officer, so much of information, whether it is amount to a confessions or not, as a relative distinctly to the fact discovered may be proved. If you are liking it, then subscribe it and share it also and press the bell icon. Thank you. Thank you.